Our next speaker is Tom Robillard. He is the Planning and Development Director for the City of Kettering. He's been a planner for more than 30 years. He's not only practiced in Ohio, but also California and Missouri. So he brings a wide range of experience to this topic today. And of course, his topic is planning and zoning. And I've found in my experience, this is the one thing that a lot of council members coming in think they know something about, but ends up they're not really quite sure what it's about. So let's all welcome Tom.
Thanks, Brian. First of all, congratulations, everybody, for winning your elected posts. That's quite exciting for you, I'm sure. My name's Tom Robillard. I'm with the City of Kettering. I've been there for about 20 years now, or 19 years. Been in this the planning and zoning field for 30 years. This is my 30th anniversary, which I can't believe it. So what I'm going to talk about today is 5 things that I think you should know about planning and zoning. And there are lots of things to know about zoning. This could take a couple days worth, but I'm going to try to give you 5 takeaways. First, I'm going to go through a little introduction, talk about process, fairness, signs, aesthetics, and plans in general. Okay, so why zoning? I understand some of you have been on planning commissions or BZAs, so you know a little bit about this. Others that are brand new to government, yeah, you may not. Health, safety, and general welfare. That's your police powers. That gives local governments, or all governments, their authority to do what they do. And that's what zoning is based on, is that health, safety, and general welfare, those police powers. Allows governments to establish procedures, regulations, and rules for what goes on in their community. The other thing why we want zoning is we live close together. If you're on a 20-acre farm, 5-acre farm even, you probably really don't care too much about zoning. But when you're on half-acre lots, third-acre lots, quarter-acre lots, or smaller, what your neighbor does directly affects you, and what you do directly affects your neighbor. So we have to have a common set of rules that we all want to live by about how we conduct ourselves on private property. It also sets community standards for how you want your community to be and look like. Do you want to have all signs look a certain way, or all buildings look a certain way, or not? It all establishes this community standard that you agree to live by. And that's kind of an important point as well, because you as elected officials are representing everybody in your community. And if you're establishing rules that affect everybody, it's got to be not just what you think, but what everybody in the community thinks. And so being transparent, being open, having procedures when you establish rules, open to the public, and getting input is going to be really important. What does zoning do? Establishes uses. What uses can be in residential areas or industrial areas or commercial areas. It also can establish rules for how, say, certain businesses operate. So if you want to regulate massage parlors, you can say, okay, massage parlors are permitted in a business district, but they have to be 300 feet away from a school and 300 feet away from another massage parlor, so that you don't get a concentration of massage parlors. So you can do things like that. Location, where buildings are located on lots, where the setbacks are. Location of uses, obviously we have different zones. So in a residential district, we have residential properties. Commercial districts, we have commercial properties, industrial, et cetera. Regulates bulk. How big can buildings be? How tall? How much square footage? An older standard used to be floor area ratio, things like that, to establish how big buildings can be. Aesthetics, basically how they look. 2 years ago, we established architectural guidelines for businesses and all properties to follow. It's been working really well for us. That gets a little bit tricky because most elected officials are not architects. Most people on staffs are not architects. So it's hard for non-design professionals to regulate design. So you have to have somebody around that knows what they're talking about. Can regulate signs. I'm going to talk more about signs in a minute because that gets very, very tricky. Tim touched on a couple of points in the last presentation that I'm going to reiterate on that. Process, how things should go, how permits should be issued, how variances should be covered, how conditional use permits or zone district changes should be established, are all part of the zoning code. And then the zoning code is two parts. There's the text, written everything down, and then there's the zoning map, which establishes the districts. This says in this area is residential, R1 or R2, however your community wants to classify those areas. One thing I wanted to touch on was, where does zoning apply? It applies to private property, obviously. It also applies to publicly owned property, parks, other properties that the city might own, government buildings. What it does not apply to typically is rights-of-way. Rights-of-way are different. They're roads for all public purpose. Zoning rules are typically designed for private property only. It does not apply to state and federal governments because we don't want to preempt, well, we're not allowed to preempt what the state and federal government can do. Now, if a state owns a property and wants to build a building on it, they still typically do follow the local government's rules for aesthetic setbacks and things like that, but they don't necessarily have to. Okay, so the first takeaway is process. This is the number one area where cities get in trouble. When you're not following the process, first thing that if it goes to court, the judge is going to look at it and say, you didn't follow your procedures, you're done. Happens all the time. I get legal brochures about planning and zoning stuff every week, and every week there's more and more cities that just don't follow a process and get in trouble. They lose. Can't basically change regulations on the fly. You're sitting in a workshop maybe and talking with your planning director and says, you know what, Tom, it would really be good if we should just allow this person to do this. That might be good, but you can't change the rule on the fly. I'm going to jump down to my third point there. You have the power to change the rules. You don't have the power to break the rules. So if you don't think something is right, there's a process to go through to change the rules. You just can't do it on the fly. Because, you know what, Kettering Medical Center, they're bringing in 500 jobs and so much money to our community. We really need to allow them to do this right now. It's like, well, that's fine, but if they don't meet the rules, they don't meet the rules. If the rules are bad, change them. And zoning is not for negotiations. I get this every day when I meet with developers. So, Tom, I've got this project coming in. I'm bringing in 20 new employees and so much tax dollars, and and I'll do this and this, but I really need you to do this for me. I really don't want to do this part of the zoning code requirements. I don't want to plant this many trees. And sorry, it's not negotiable. I have to follow the law like everybody else has to follow the law. It's there. There's a process for changing it if you want to change it, but it is what it is. So it's not up for negotiations. Most things that you come up with is conditional use permits, variances, PUDs, zone district changes. All those typically have different procedures to follow. So, for instance, in Kettering, conditional use permits, they go to our planning commission and are approved by the planning commission. Once they approve it, that's it. Someone can appeal that to the city council, but that's all the procedure goes. In other communities, it's different. Zone district changes are different. That's a legislative authority for the city council. That might go to your planning commission for a recommendation to the city council. But again, procedures that need to be followed for that. Variances are a different animal, and I could talk for an hour on just variances. But talk to your legal department when you have appeals to variances, because they can get very, very tricky. Last point I wanted to make is the rights of the applicant are the same as the rights of the general public. So you may want to notify more people on a particular hearing with legal notices than what's required by the zoning code, but now you're stepping on the applicant's due process rights. So you have to be very, very careful about what you do when dealing with procedures from applications. Fairness. This is the second area that local governments get in trouble with, is treating people differently, unfairly. The zoning code is not there to discriminate against one person or another, against one type of business owner or another, one type of income versus another. That's not what it's there for. Don't try to make it that. There's been a long history of zoning that has been discriminatory in practices. Hopefully we are on the mend and trying to change those around and correct those discriminatory practices. I hope so. It's not a place to say who can and who can't live in your community. I get this a lot, particularly an apartment building wants to locate in Kettering. Well, I get calls all the time, oh my gosh, there's going to be low-income people moving in there. And it's like, how do you know that, number one? Number two, I don't care. That's not what my legal authority has anything to deal with, nor the local government has any legal authority to deal with. It is what it is. People can rent or sell their houses to whomever they want. It's not for the government to make that decision. A lot of it is funneled down through the Fair Housing Act that tells us a lot about what we can and can't do as from local governments, particularly in zoning, about treating other people differently. So if we fall afoul of that, then it's a federal crime, and we just don't want to do that. It's not a place to push beliefs. A lot of communities have gotten in trouble because, you know what, we're a good Christian community and this person wants to come in and build a mosque. You've seen this in the news throughout the states in different places. No, the places of worship, that's it. You can't, the zoning code is not a place to push different types of beliefs that way. Signs, that's the third area where most communities get in trouble. Content neutrality. Your sign regulations have to be content neutral. You can't regulate what a person says on a sign. Can a community regulate off-site signs? The answer is no. If you have to read the sign to determine what it is, you can't regulate it. You're regulating the content. You can regulate time, place, and manner. Tim brought that up earlier about what you can say during council meetings. You can't regulate signs any more than where they go, how they go, and their time. So that's manner. You can regulate their height, the size. You can regulate aesthetics. You can regulate where they go on a building. Are they freestanding signs in the lot? Are they temporary signs? Are they permanent signs? You can regulate that. Now, there is a part that local communities can regulate between commercial speech and non-commercial speech. But that gets very, very tricky because if you do that, then you're going to be held under what they call strict scrutiny. And the courts have a whole different standard of looking at you and where you have to fall if you start trying to regulate between commercial speech and non-commercial speech. You can do it, but you got to be extremely, extremely careful and diligent. Otherwise, time, place, manner. Real estate signs. You got to read it to know what it is. Political signs. You got to read it to know what it is. So you can't regulate those things. And Kettering, like I said, we updated our zoning code. We really tried to focus in on how we regulated signs so that we were content neutral. So far, so good. I'm not saying that it's perfect, but I think it's good. But so for temporary signs, we just say temporary signs can be 12 square feet in area. In residential areas, no more than 4 feet high. In commercial areas, no more than 6 feet high, or something like that. Ground signs can be 6 feet high and so many square feet. If you've got a site bigger than 2 acres, you can have a taller sign. Things like that that regulate the time, place, and manner. Billboards. If your definition of a billboard says that it advertises off-premise stuff, again, you got to read it, and you can't regulate that. Aesthetics. This is probably the most helpful aspect and impactful aspect of your zoning code. It really establishes how you really want to look like. You don't have to have aesthetic criteria in your zoning code. You can just simply have setbacks and height requirements and then regulate uses, and that's perfectly fine. If you want to regulate aesthetics, I talked about that a little bit earlier, you got to be very careful because you really have to know what you're talking about, or have staff people on that know what they're talking about with design. But it does have the biggest long-term impact on your community. This is a great example of a plaza in North Carolina. Great looking development. Very nice. The landscaping was beautiful. The architecture was beautiful. Very well planned out and all regulated that way. Residential homes, you probably don't want to regulate too much, but you may want to regulate that the building material can't be, you don't want to have corrugated metal roofs. So you can say no corrugated metal roofs, but basic things like that are great to establish that parameter. And believe it or not, if you don't have those, people will build whatever they want. Yes, sir.
With respect to aesthetics, residential in particular, I mean, can you, like, you have to be specific and how specific? We want it to look nice. Well, what's nice? Or what kind of things?
Yeah, great question. In Kettering, we used to have a requirement that it had to be aesthetically pleasing. When I came in here, it was like, what does that mean? I don't know what that means. Now we have requirements that says, well, it's got to be a typical residential material such as, and we have a list of, 10 different sidings types. But you're not allowed to have corrugated metal siding. You're not allowed to have, I can't remember something else. Cardboard, yeah. Something that's going to deteriorate. For commercial buildings, though, we get a lot more specific and saying that you've got to have expression lines, and expression lines are a delineation between, say, first story and second story. Over the public entrance, it has to look like a public entrance by either providing an awning over it or having a taller parapet over it, but something that calls attention to that it's a public entrance. So yes, you do need to get very specific about those things. Otherwise, you're leaving it up to interpretation, and then you're going to get in trouble for being arbitrary and capricious. Lastly, plans. Being a planner, I really like plans. Plans are really fun because we get to think about the future. What do we want to be in 5 years? What do we want to be in 10 years? Sometimes even longer. But that gets very, very difficult, particularly for people that are not used to thinking about things 5 years from now or 10 years from now. That's just a really long time to think about. But for a community, for a business, it really is important. Where do you want to be in 5 years? We want to have Town and Country Shopping Center. You're all familiar with that. We want to see that redeveloped. So what are we going to do about it? Well, the first thing is we want to do public improvements. And so we want to make the sidewalk really nice, and we want to plant some trees in the public right-of-way, want to create a median. And so then we establish we're going to do those things in our capital improvement program in years 2 and 3. But on the private sector side, we want to work with the developer on doing, making improvements. So we're going to maybe create an incentive program for them to do that. We're going to remodel or rewrite our zoning code so that it makes it easier for them to put in outlots or something like that. So a plan is, having all those things in place so that you can get there in 5 years. You're going to be, 5 years from now, you're going to be 5 years older, and you're either going to be where you want to be or not. And a plan is basically it's a roadmap. How are you going to get there? And the tools that you're going to use, those are your vehicles. You can either drive in a Cadillac or you can drive in an old Pinto. I always love a conversation starter is, what was your first car and what did you love about it? And for guys, it's always, well, older guys, it's always a fun thing to talk about. But yeah, we were a 5 Pinto family. But anyway, so your zoning code is a tool to get where you want to be. Your capital improvement program is a tool to where you want to get to. Your subdivision code is a tool to help you get where you want to go. And then you can decide whether you want to get there now or take your time with it. That also gets established in your plans. So the takeaway there is your zoning code should follow what your long-term plan is and not vice versa. A lot of communities say, yeah, our zoning code is our plan. And in Ohio, that's perfectly allowed. That's okay. But it's not very dynamic. It doesn't really tell the community where you're going. That's it. That's me. If anybody ever wants to get a hold of me.
Thank you, Tom. That's, again, a very important topic. Please take the opportunity to get involved with that and to take a good look at your codes. And if you have any questions, please ask your staff, because it is a very detailed process and very important one.